there, everyone. Welcome back to another episode of Law Schoolers. In this episode, we are talking about the invocation, meaning actually invoking, and waiver of Miranda rights. How do you invoke your Miranda rights, and then also how can you waive your Miranda rights as far as the subjects go? So subjects are free to waive their Miranda rights, and the majority of individuals actually do waive their Miranda rights. I think about 80% of people waive their Miranda rights. Although the history of how to waive has actually been significantly altered. Originally, it was on the burden of the prosecution to show that a waiver had been made. But over time, now is the responsibility of the subject, meaning the defendant, to assert their rights by a clear and unambiguous language or actions. And if you fail to assert those rights clearly and unambiguously, well, then it's going to be deemed that a waiver of those Miranda rights has occurred. So we have here Commonwealth versus Clark, which is going to illustrate the difference between the federal standard and then also some narrower limitations that states may constitutionally create. So what is the federal rule for waiving rights? Well, a suspect must unambiguously invoke the right to counsel or the right to silence. If the suspect does invoke their rights, officers are able to resume questioning later if they honored the original request and the questioning resumes after a long break, and the scope of the questioning is about a different crime. This federal test is outlined in a case called Mosley. Now, Massachusetts here, they decide to adjust this rule based on their state. They have broader protections for people who are in questioning. Essentially, what their rule is if the waiver is going to be ambiguous, then the police must ask a clarifying question to determine whether or not the subject actually had the intent to waive their rights. If the subject does invoke their rights, well, then that request needs to be scrupulously honored. So in Miranda, it said, if the defendant indicates in any manner at any time prior or during questioning that he wishes to remain silent, questioning must cease. This test was actually altered with Tompkins, which was the case about silence, and then Davis, which was the case about the right to counsel. In Tompkins, the defendant there had remained silent for nearly 3 hours before saying only one incriminating word. In that case, the federal court determined that this was not an invocation of your Miranda rights, and thus, by saying that one word, you had waived your Miranda rights. In other words, this was not an unambiguous assertion of the rights. It was ambiguous, and in the federal case, that means that this was waived. In this case, and underneath application of the federal rule, there was an unambiguous assertion of rights. What happened here is that the defendant was asked, do you want to speak? And the defendant shook their head no. The next question that was asked after they shook their head, they ended up continuing to push and attempt to question. And the question is, did the officers honor the request when the defendant had shook his head no? The answer to that is no, because they continued questioning right after that initial response, and they continued questioning about the same crime. So underneath the federal rule, this failed, but in Massachusetts ended up broadening its protections, and so because the state rule is more protective for defendants, it's clearly a violation in this case of the officers continuing to question the defendant. So we look at another case, State versus Ortega. What happened here is that the subject was charged with murder, and as he was being charged or just talking with the officers, he asked, am I supposed to have a lawyer here? At that point, he received a clarification about his lawyer rights before he signed a form waiving his rights before questioning. So he asked, am I supposed to have a lawyer here? He was then provided clarification, and then he signed a waiver of his Miranda rights, and then the officers ended up questioning him. So the question in this case is whether that statement of, am I supposed to have a lawyer here, if that is a invocation of their rights, or if it is a request for clarifying information. Underneath the federal rule, this is not an assertion of the rights. It's ambiguous, and it could have been interpreted either way. But in Minnesota, where this court actually took place, it requires the clarifying question approach. Here, there was a clarification that did occur, and so this was a valid waiver of the Miranda rights. So what are some examples of ambiguous assertions? This case provides a prime example. Am I supposed to have a lawyer here? Or do I need an attorney? Or maybe I should talk to a lawyer. Those are all examples of ambiguous assertions where underneath the federal rule, if it is ambiguous, it is not a waiver. And then in certain states, if it is ambiguous, well, then you need to ask a clarifying question. Then we have State versus Reed, and this is the final case that we discuss about the invoking or waiving Miranda rights. Reed had discovered a coworker's body, and Reed's girlfriend called the police about the discovery. The girlfriend called an attorney to represent Reed, and then Reed was never informed that an attorney had been retained by the girlfriend for the defendant. Reed was never informed, and then he waived his rights, and in subsequent interviews, Reed actually confessed to murdering the coworker that he had discovered. So, under the federal rule, and then underneath the state rules, what are the rights here? Well, under the federal rule, there is no need to inform Reed that an attorney had been retained by a third party because that information doesn't affect the subject's personal waiver of their rights. This rule is outlined in Miranda versus Burbine, and then it would have been a different story, though, if the subject had a lawyer previously retained, not by a third party, but the actual subject, the person who is being questioned regarding the crime. If that person had previously retained an attorney, well then, if the officers do not inform the subject of an attorney being present, well then they would have unknowingly waived their rights, and it would have been an invalid waiver. Most states have rejected the Miranda approach, which means even if a third party does obtain a lawyer for somebody being questioned, well then the officers need to inform the subject that a lawyer has been retained. Failure to do so would mean that any waiver would have been unknowing, and thus the waiver would have been invalid. In this case, in State versus Reed in New Jersey, the court rejected the Miranda approach and said that the police must inform the subject about the attorney's arrival. So those are our takeaways about the waiver, invocation, and invocation of Miranda rights. We talked about the rule for how you need to invoke it. It needs to be unambiguous underneath the federal rule, and it is up to the defendant to prove that it is unambiguous. And if it is unambiguous, well then police may later resume questioning if they honor the original request, if the questioning resumes after a long break, and then the scope of the questioning is going to be about a different crime. Several states broadened this approach, saying that if the waiver is ambiguous, well then the police need to make sure that they clarify the knowledge of the defendant to make sure that any waiver is then unambiguous. We talked about some examples of what might be an unambiguous or ambiguous assertion. An ambiguous assertion example of that is, do I need an attorney? Or maybe I should talk to a lawyer. An example of unambiguous would be, I would like to have my lawyer present. In State versus Reed, we also talked about a third party retaining a lawyer underneath the federal rule. Officers don't need to inform a subject that a third party has retained a lawyer, but most states reject that rule and say that if a third party obtains a lawyer, they need to inform the defendant of that lawyer being retained. All right, that's all this material. We've only got 5 more episodes after, well, I guess we have 5 more. And I will see you later. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is, if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is, if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.